My name is Thomas Lindsay, and I'm the senior attorney for a Pacific Northwest-based nonprofit organization, the Center for Democratic and Environmental Rights. And it's our pleasure to welcome you to this new Seeley class, the inaugural voyage of this class entitled The Rights of Nature, Theory, Laws, and Emerging Jurisprudence. I'm joined today by my colleagues who work within this newly emerging field. Daniel Brannon from New Mexico, Melissa Morton from Oregon, and Nayeli Velasquez from California. The goal of this webinar, the overall goal, is to give you a working understanding of this emerging field of environmental law, where it is taking root, some of the jurisprudence around it, and then finish up with a panel discussion focused on challenges and obstacles that practitioners in this field have faced and ones that they will continue to face in the future. So without delay, let's get started. So again, the title of the Seeley class today, The Rights of Nature, Theory, Laws, and Emerging Jurisprudence. And again, my name is Tom Lindsay, and I'm an attorney with the Center for Democratic and Environmental Rights. And again, our presenters today from across the United States, myself from Washington State, Daniel Brannon from New Mexico, Melissa Morton from Oregon, and Nayeli Velasquez from California. The rights of nature, the reason why we're here today for this Seeley class, kind of play in four parts. These are the four major items that we're going to cover during the Seeley class. Part one is focused on rights of nature as a legal theory, this concept of legally enforceable rights for ecosystems, kind of civil rights type protections for ecosystems in nature. And we're going to talk a little bit about the origins of recognizing legal rights for ecosystems in nature, as they're rooted in indigenous cultures and how those concepts move to the Western system of law and form the basis for what we're going to be talking about today. Part two of the four parts, we're going to do an anatomy of rights of nature laws that have been passed in the United States at the municipal level. So within cities, towns, counties across the United States. And Dan is going to take us through some case studies of several seminal U.S. rights of nature laws that have been adopted. Part three focuses on international rights of nature jurisprudence. And Mel is going to take us through several case studies of some seminal cases from other countries, including Ecuador, Bangladesh, and India. And then part four, we're going to do a recap of the major concepts that we reviewed during the class and focus on a panel discussion on the various issues that practitioners have faced when working on rights of nature laws and enforcement of those laws. So just to jump into those various parts. Part one is focused on the rights of nature as a legal theory. And these are the kinds of questions that we're going to try to answer during this section. Number one, what does it mean when we talk about rights of nature? What's the meaning of that phrase as it's come to be known as a contemporary movement in recognizing legally enforceable rights for nature? What are the indigenous origins of the concept? How are the foundations of the existing Western system of law different from those indigenous origins? When and how did the concept emerge into Western law? What was the transition from those indigenous concepts into emerging into that Western system of law? When were the first rights of nature laws adopted in the United States? And have tribal governments in the U.S. adopted rights of nature laws? And if so, what issues have they tried to address through the adoption of those laws? Part two, again, focused on the anatomy of these rights of nature laws in the U.S. and case studies of seminal laws that have been passed in the United States, including the city of Pittsburgh, which adopted a rights of nature law in 2010. So we're going to use the Pittsburgh Rights of Nature Ordinance to essentially look at the parts of these rights of nature laws. Declaration of legally enforceable rights, recognition of standing, answering the question of who can step into the shoes of these ecosystems or nature to enforce these rights, and the provision of remedies, including restoration, the type of remedies that are available for actions brought to enforce those rights. We're also going to take a look at enforcement of rights of nature laws, including a recently filed case in Florida known as Wild Cypress Branch versus Beachline South Residential LLC, to look at rights of nature in practice. What do they look like when they're actually used in the U.S.? And what kind of issues arise when you attempt to enforce these municipal laws against actors and activities that are violating those rights? And finally, we're going to take a look at ecosystem intervention in existing cases using a couple of seminal cases examining ecosystems attempting to intervene in those existing cases. Part 3, we're going to look at international jurisprudence and laws. The Ecuadorian Constitution is going to be a focus at the beginning. Passed in 2008, first national constitution to incorporate rights of nature provisions. We're going to take a look at enforcement cases brought under those constitutional provisions, and then look at rights of nature jurisprudence rulings in Colombia, India, and Bangladesh. And Mel is going to take us through that part. And finally, part 4, we're going to recap the major concepts from this class, and then do a panel discussion amongst the 4 of us on issues that have arisen around drafting, the lawmaking process itself, the role of municipal governments in the United States in terms of adopting those laws within the municipal structure, and then look at enforcement challenges for rights of nature work. So again, without delay, let's jump in. First part of today is rights of nature legal theory. And in very basic terms, what is it? And where does it come from? What does it mean when we use the phrase rights of nature in a legal sense? The best definition that we've seen so far for this rights of nature concept is really the recognition by legislation or jurisprudence of the legally enforceable rights of nature, ecosystem, and species. And sometimes it bends our brain slightly to think about kind of civil rights for ecosystems, human civil rights type protections for ecosystems. But that's what we're talking about today when we talk about rights of nature and these laws and court decisions that have moved around the globe. Basically, an understanding that the current system of environmental regulation and environmental laws that we have left us short in terms of environmental degradation and destruction, and leaving communities without the necessary tools that they need to protect the natural environment. So again, recognizing by legislation or jurisprudence the legally enforceable rights of nature, ecosystems, and species. In other words, legal rights in law, human civil rights type protections for nature as a whole, natural ecosystems or native species. And again, generally seen as an attempt to strengthen existing environmental laws by heightening the types of protections afforded to nature, kind of putting in place more stringent environmental protection measures that are anchored on rights akin to those human civil rights type protections that we're used to seeing in the U.S. Constitution's Bill of Rights or in State Bill of Rights, but providing that heightened level of protection to nature. So that's what we mean when we use the phrase rights of nature, at least in a legal sense. As I mentioned earlier, rights of nature has indigenous origins. Most folks trace it back to this indigenous understanding of nature as something else other than property, that nature can't be something that can be owned. And we see that mostly in a contemporary sense, at least with tribes that treat nature as a living being or as a relative of sorts. So an animated object. But you hear, for example, the White Earth Chippewa people in Minnesota talking about the flying people and the swimming people and the singing people, not as a dead thing, but as an animated object. And the Yurok Nation in Northern California talks about the Klamath River as a relative or as a living being. So indigenous origins for this understanding that nature is something else other than property, can't be owned or exploited as property. So when we contrast the worldviews between how a Western or European system of law, which most of us practice within, compares with this indigenous cultural treatment of nature. And we did this slide to kind of give that comparison between the two. But under an indigenous cultural system, and these are all generalities, of course, but nature is treated as a living being. And again, the Anishinaabe people, I think, kind of punctuates this argument by when they speak about nature, and birds and salmon as the flying people, the swimming people, and the singing people, and the Klamath River being treated by the Yurok Nation as a relative or a living being. And so we contrast that with how the Western system of law treats nature and ecosystems, that nature is kind of a dead thing whose exploitation is to be regulated. And my favorite quote, infamous quote, I guess, from Sir Francis Bacon, a European philosopher, who put it this way, that the goal of Western civilization, or something that Western civilization absolutely needed, was to torture nature on a rack to extract her secrets. So we have this Western system of law that treats nature in a certain way as property to be used by its owner, and of course, as part of the bundle of rights of ownership of an ecosystem, ownership of land, ownership of nature. One of those rights is the right to destroy property, and treating nature as subordinate to that property ownership piece. And of course, under the Western system of law, once something is denoted as property, as nature and ecosystems are property under the law, then all kinds of constitutional protections then rise to protect that ownership of property. In other words, a constitutional violation of taking that property for certain use. And so constitutional protections of property accrue around that ownership concept, or that bundle of rights for nature as property. So again, just a quick contrast between indigenous cultural systems in general and this Western system of law that we have in the U.S., which was mostly inherited from England, but this Western system of law, European system of law. So how did rights of nature kind of move from this indigenous concept into a Western system of law that's mostly hostile to this concept of legally enforceable rights of nature? And most folks trace it back to Professor Christopher Stone from the University of Southern California. Christopher Stone recently passed on May 14th of this year, 2021, at the age of 83. One of his huge contributions to environmental law was to draft a law review article that had the provocative title of "Should Trees Have Standing Towards Legal Rights for Natural Objects?" It's published in 1972. And just to read a paragraph from that piece, because it was so important to the evolution of this rights of nature jurisprudence and movement in the United States. He wrote, "The fact is that each time there is a movement to confer rights onto some new entity, the proposal is bound to sound odd or frightening or laughable. And this is partly because until the rightless thing receives its rights, we cannot see it as anything but a thing for the use of us, those who are holding rights at the time. The reason for this little discourse on the unthinkable is that I'm quite seriously proposing that we give legal rights to forests, ocean, rivers, and other so-called natural objects in the environment, indeed to the natural environment as a whole." So kind of a novel idea, at least in Western law, not novel to indigenous cultures, but first time that it really poked its head into this Western system was through Professor Christopher Stone's piece, "Should Trees Have Standing?" And it came kind of during the emergence of a perfect storm, because like most law review articles, it may have gotten lost in the shuffle in terms of getting published and sitting on a shelf, but Christopher Stone's piece was immediately injected into a case that was making its way into the U.S. Supreme Court. And the name of the case was Sierra Club versus Morton, citation 405 U.S. 727, again, 1972. And for our purposes here, for the Seeley class today, just an overview of how the case came to fruition, how it emerged in the U.S. Supreme Court. There was a proposal by the Walt Disney Corporation to put in a ski resort in Mineral King Valley in Eastern California. Suffice it to say, huge development. We're talking 1.7 million annual visitors, bigger than Disneyland. Usually that's as much as we need to know. The Sierra Club sued to stop the development from proceeding. And the lower courts dismissed the Sierra Club for not having standing. In other words, that no Sierra Club members would be injured by the proposed development. That's the current test, of course, in environmental and other cases, that if you sue as an organization, you have to have members that have been physically injured or aesthetically injured or show some kind of physical injury under the Article 3 standing tests developed by the Supreme Court and other courts pursuant to the U.S. Constitution. So the lower courts dismissed the Sierra Club and said, you don't have standing, you haven't been injured by the proposed development, you can't challenge it. And the Sierra Club appealed to the United States Supreme Court. And it's here where Christopher Stone's piece got leverage, as they say, making its way into a dissenting opinion. And it was only a dissenting opinion because the court itself decided to affirm the lower court's dismissal of the Sierra Club, so dismissing the case. Justice William O. Douglas, one of the most progressive justices that's ever served on the Supreme Court, wrote a dissenting opinion in which he cited Christopher Stone's article. Some of the backstory is that Christopher Stone rushed the article to publication just so Justice William O. Douglas could cite from it for this particular dissent. But just to read a paragraph from that dissent by Justice William O. Douglas, he wrote, "A contemporary public concern for protecting nature's ecological equilibrium should lead to the conferral of standing upon environmental objects to sue for their own preservation. This suit would therefore be more properly labeled as Mineral King versus Morton, i.e. the valley that was being affected or developed versus Morton. So it should be as respects valleys, alpine meadows, rivers, lakes, estuaries, beaches, ridges, groves of trees, swampland, or even air that feels the destructive pressures of modern technology and modern life. The river as plaintiff speaks for the ecological unit of life that is part of it." And when was the last time that that kind of language was injected into the U.S. Supreme Court decision? It's been a while, but this was 1972 again, Justice William O. Douglas building off of Christopher Stone's law review article. So the question that we get quite a bit is, well, what happened next? There was this dissenting opinion, put out this new kind of idea based on this law review article, and the short answer is almost nothing happened. So the dissent came out, the law review article was published, not much happened. Not quite true, because some practitioners began actually trying to use this in mostly Endangered Species Act settings. And so post-Morton, after the litigation was finished, there were practitioners across the United States, environmental law practitioners, who tried to pick up the concept and use the idea to inject animal and plant species as plaintiffs into litigation. And there have been quite a few. This is not an exhaustive list, but this is a chronological list of some of the most important cases that were brought under this new kind of creative new lawyering effort to add species as plaintiffs in Endangered Species Act, mostly Endangered Species Act cases. And just to run through these really quickly, there was a case that in which the Scotchman's Peak grizzly bears, just a little bit south of us in Spokane, Washington, brought a case. That case dealt with mineral drilling in the Cabinet Mountains Wilderness area to try to stop the mineral drilling from moving forward. That was the D.C. Circuit. Palila versus Hawaii Department of Land and Natural Resources. The palila is a native bird in Hawaii. And the challenge was that the United States, or the Hawaii Department of Land and Natural Resources, was allowing herds of feral sheep and goats on the slopes of a volcano, which were affecting the palila's ability to survive in that particular region. There were the northern spotted owl cases. Who can forget those? Back in the 80s and 90s. These were two cases brought in the name of the spotted owl as the bird species. Against the U.S. government, basically over a decision not to list the northern spotted owl as endangered. That was the Hodel case. And then a suit over the decision not to list critical habitat. That was the Lujan case, both brought by the northern spotted owl as a plaintiff in the Western District of Washington federal courts. There was the Hawaiian crow versus Lujan case. That was a suit to force the federal government to protect the Hawaiian crow on private land. The federal government was refusing to put certain restrictions on private land use. That was the district court in Hawaii in 1991. There was the Mount Graham red squirrel versus Uter case. That was to force federal government to designate critical habitat for the red squirrel. There was the Citizen Stand Animal Suffering and Exploitation versus New England Aquarium case. That was a case brought to end the transportation of a dolphin in violation of the Marine Mammal Protection Act. So that was 1993, not an Endangered Species Act case, but a Marine Mammal Protection Act case. Also, many may remember the Marble Murrelet case versus Pacific Lumber Company back in 1995. that was brought on behalf of an endangered bird, lawsuit against logging of old growth forests that affected the murrelet. The loggerhead turtle case versus County Council of Volusia County in Florida, and that was brought in 1995. Basically, a challenge to artificial beachfront lighting that was interfering with loggerhead turtle nesting sites. A fascinating case. Loggerhead turtles were the plaintiff, brought in Florida in 1995, and then again in 1996, another marbled murrelet case, same issues. And then finally, the case captioned Cetacean Community versus Bush. And you have the citation there, 2004. In the Ninth Circuit, it was the National Environmental Policy Act case, essentially challenging the failure of the Navy to prepare an environmental impact statement on low-frequency active sonar used by submarines, used by the Navy for submarine training. And so brought in the name of the cetacean community, whales, porpoises, dolphins, versus President Bush for the Navy's endangerment, which was the allegation of the cetacean community through that low-frequency active sonar that was happening from submarines. So some of the creative lawyering that took place, how did they go? Well, the answer is that in the beginning, in the 1990s, when some of these cases first broke the surface, you had some courts willing to entertain kind of the concept of a species as a plaintiff. And so the high point was the Palila case in 1998, in which the Ninth Circuit wrote, first they recounted the earlier Palila case, but wrote the Hawaiian Palila bird, quote, has legal status and wings its way into federal court as a plaintiff in its own right. And they had written previously further that the Palila had earned the right to be capitalized since it is a party to these proceedings. So again, kind of the high point of this integration of Christopher Stone and the dissent moving into these species as a plaintiff in Endangered Species Act cases. Contrast that to the cetacean community ruling, which happened in 2004, in which the Ninth Circuit kind of withdrew any kind of even tangential support for finding a plant or animal species as a plaintiff in the contour or framework of the Endangered Species Act. In 2004, they wrote, after due consideration, we agree with the district court that our statements in Palila are non-binding dicta. If Congress and the President intended to take the extraordinary step of authorizing animals as well as people and legal entities to sue, they could and should have said so plainly. In the absence of any such statement, we conclude that the cetaceans do not have statutory standing to sue. So 2004 versus 1988. 1998 approaches by the Ninth Circuit on standing of species in Endangered Species Act and Marine Mammal Protection Act and also National Environmental Policy Act scenarios. So in addition to this judicial effort, effort by practitioners to drive animal and plant species as plaintiffs, starting in 2006, municipalities, so cities, towns, villages, and counties across the United States, began adopting rights of nature laws that kind of expanded the concept by recognizing these legally enforceable rights within municipal frameworks of law. And we're going to take a look at a couple of those before I turn it over to Dan to do the next section, looking at the anatomy, a closer look at some of these laws that have been passed in the United States. So one of the seminal moments in the development of rights of nature jurisprudence, rights of nature laws, was in 2006 in a small community called Tamaqua Borough, Pennsylvania. So just northwest of Philadelphia, about 7,000 people in this particular municipality. And they became in 2006 the first first municipality, first government to adopt a rights of nature law. So the first one in the world to adopt a rights of nature law. And as with most laws, as we'll see over the course of this class, these laws have been developed and adopted in response to a particular harm or a particular threat. The threat in Tamaqua Borough was that they were faced with a project, state-sponsored, to dump PCB, polychlorinated biphenyl-laden dredge, very dangerous, toxic constituent, from the Delaware River into this small borough, into Tamaqua Borough. So faced with a project to dredge the Delaware River, then dump the tailings, the residue, the dredge itself, which is laced with PCB, into this small Tamaqua Borough. Tamaqua Borough is home to a couple different creeks, also Little Schuylkill River, which is part of Philadelphia's drinking water supply. And so folks there were very concerned about the potential for this PCB-laden dredge to pollute those water supplies and those creeks. Influenced by the case, Sierra Club versus Morton and Stone's article, some of the early work around rights of nature stuff, the Borough Council adopted an ordinance, municipal law, recognizing the rights of ecosystems, including those creeks and the Little Schuylkill River. And this is the most important part, of course, of what they did, because the content of the ordinance is so important. But they recognized these constitutional type standards to exist, flourish, and naturally evolve for those ecosystems within Tamaqua Borough. And they also banned the dumping of the PCB-laden dredge in the community into Tamaqua Borough. So again, the standard exists, flourish, and naturally evolve, but recognizing legally enforceable rights for ecosystems within the municipality. And again, as I said earlier, sometimes it's tough to bend our brains around this concept of human civil rights type protections, heightened protections for ecosystems. But that's exactly what Tamaqua Borough did back in 2006. Again, exist, flourish, and naturally evolve were the standards that they used. Folks may have heard about the Lake Erie Bill of Rights in 2019, one of the most recent rights of nature laws passed in the United States. Again, the actions of the people of Toledo in passing the Lake Erie Bill of Rights in 2019 was long coming and was a response to threats and certain things that were happening within Toledo, starting back in 2014, where they had a cyanobacteria algae bloom that shut down the water supply for 3 days. In 2015, the algae blooms continued. 2017, again, tied for third largest on record. Folks in Toledo, Toledoans for Safe Water, was the community group in Toledo, drafted a Lake Erie Bill of Rights, which asserted that Lake Erie had the rights to exist, flourish, and naturally evolve, and that residents of Toledo were recognized having a legally enforceable right to a clean and healthy environment. And in February of 2019, 62% of Toledo voters voted to approve that Lake Erie Bill of Rights. So again, City of Toledo, Ohio, Lake Erie Bill of Rights 2019, and the events leading up to the passage of that Lake Erie Bill of Rights on the ballot by popular vote after all these water quality issues had occurred within the City of Toledo and within Lake Erie. Folks may have also heard about Orange County, Florida. It's the 30th largest county in the United States, 1.5 million people, so a big municipality, unlike some of the smaller municipalities over that past 14 years that had passed similar laws. Again, arising from a particular crisis. And here it was the water crisis in Florida, red tide, algae blooms, die-off of marine life, and environmental leaders in Orange County drafted something that was known as a Right to Clean Water Initiative. It recognized a right to clean water for people within Orange County, but it also recognized the Wekiva River, Econ-Lockhatchee River, and all waters in Orange County as having the rights to, quote, exist, flow, be free of pollution, and maintain a healthy ecosystem. And I think to some people's surprise, given the content of the initiative, in November 2020, it passed with 89% of voters in favor. So folks that have not worked with initiatives in the past, 89% is a huge number for voters that voted in favor of it. And so that's Orange County, Florida in November of 2020. Tribes have also passed rights of nature laws in the United States, and which is, of course, kind of logical because of the indigenous underpinnings and anchors of the rights of nature concept. Nature is not property. So the Ho-Chunk tribe in Wisconsin, the Ponca tribe in Oklahoma, the White Earth Ojibwe, the Anishinaabe people in Minnesota, the Menominee tribe in Wisconsin, the Yurok Nation in California, and most recently the Nez Perce Nation right down the road from us in Spokane, Washington, in Idaho. Passed a tribal law recognizing the Snake River as having certain rights. So tribal nations have been very active at the tribal level, passed either with it as a constitutional provision within the tribe's constitution or as a regular tribal law passed by the business committee or other governing entity for that particular tribal nation. And just to highlight one of these, the White Earth Ojibwe in Minnesota in 2018, the White Earth Business Committee, which is the reservation's governing committee, elected officials, and the 1855 Treaty Authority, which is an entity put together to oversee traditional tribal lands outside of the reservation that were recognized for use rights for the tribe outside of reservation land, adopted the world's first rights of nature law that protected a plant species specifically back in 2018, monomen, or wild rice, and the law recognizes the rights of wild rice to, quote, exist, flourish, regenerate, and evolve, as well as inherent rights to restoration, recovery, and preservation. And again, that's the White Earth Ojibwe in Minnesota. And just recently, after we had put the PowerPoint together for this particular class, the White Earth have also created an off-tribe court, off-tribal reservation court, specifically to hear claims about activities that may violate the business committee's laws and the 1855 Treaties Authority's laws, even if they occur outside the reservation land. So that's an interesting development as well, because the rights of nature laws may be enforced eventually in that off-tribe or off-reservation tribal court that's been formed. So just to summarize this part of the presentation before I turn it over to Dan, to talk about, take a closer look at the anatomy of these laws and look at some of the case studies of enforcement of these laws in Pennsylvania, Oregon, and Ohio. Today, as of the date that we're doing this Seeley class between municipal and tribal rights of nature laws, we have a little over 36 municipal and tribal governments have adopted rights of nature laws across the United States. So it's as of 2021. About 36 municipal and tribal governments have adopted these rights of nature laws across the United States, and so it's a growing field of environmental law at the municipal level. So with that, I'm going to turn it over to. We've arrived at the end of part one.